questions will be asked after you finish your lecture.
Right, sir. So present count is 145 and 2 minutes left to start.
Yeah.
Sir, quickly, can we have a list of the co-hosts?
Sanjay sir, Rohit Gandhare, and Hemant Puri, Deepak Durga.
And I think when sir has already joined, Anup make sir also as co-host. Sir has already joined, I think so. Just check it, please.
Yes, yes.
Yes, sir, I will check.
Yeah. Rohit, over to you.
Sure. Thank you so much, Sanjay sir. And good morning, one and all. And on behalf of Rajshri Shahu College of Law, Vikhroli, Mumbai, myself, Rohit Gandhare, welcome you to another exciting session, another exciting webinar on the fundamental rights enumerated on Constitution of India by our eminent speaker, Shri Puneet Chaturvedi sir. Shri Puneet sir, please confirm your presence if you have joined so that we can begin the session. Puneet sir?
Anup, just check whether Puneet sir is unmuted or not.
Rohit sir is there, but I guess he has not on his audio yet.
Okay, we'll wait for some time. Puneet sir, this is a request to you. If you can hear us, we need your go ahead before we start.
Yes, we can see him. Puneet sir, you need to click on the video on the audio mode, sir. Sir has already joined, but I think his audio is off. Puneet sir, can you click your? I'll just wait, sir. I'll message him. Sir has already joined, but I think his audio is off. Sir, click. I have sent him the WhatsApp message. I think he is not checking it. Should I give him a call?
Yes, he is already unmuted.
I'll give him a call. I might get disconnected if I give him a call. Sir,
should we send private message to him?
I have sent the private message to him. Or send in the chat box, please.
So you will not be disconnected if you make a call.
Yeah.
Sir, I am on laptop. So should I give him a call, Kailash here?
Yeah, give him a call, sir, Kailash, quickly.
Okay.
And tell him to call the device mode. Call via device mode.
Okay.
On.
Okay, sir. Okay.
Yes.
Sir, his phone is switched off.
Sir.
His phone is switched off.
Okay. Puneet sir, can you please click call via device mode, please?
नहीं सर, वो बोल रहा है कि उनको सुनने को नहीं आ रहा है.
नहीं, बट मैं उनको ऐसा थोड़ा लिप मूवमेंट के थ्रू समझाने की कोशिश कर रहा था.
सर, आप इसमें जूम का चैट में लिखिए ना, वो जूम का चैट देखेंगे.
जूम चैट. हाँ जी.
हाँ पुनीत सर, आपने जब लैपटॉप से ज्वाइन किया होगा तब ऑडियो में एक ऑप्शन आता है, तब शायद आपने डिवाइस का ऑप्शन चूज नहीं किया होगा, मे बी. तो can you do it again, sir? सर को सुनाई नहीं दे रहा शायद.
Samson sir, can you do one thing, Mr. Samson Bhandari sir? Can you write a message on the wall behind you if it is a blackboard, whiteboard, that Puneet sir join in this fashion so that it gets reflected to everyone and especially to Puneet sir.
Sir, I have a whiteboard. You want me to write and show
Yeah,
the-
yeah, write it and show on your video. Puneet sir is trying to to speak because we can see his.
He's not able to hear us.
Yeah, he is there on video, but we cannot hear him. Or
Sir, do just a placard. We can show him. Somebody can show him through a placard writing that this is to be done.
Hello, hi,
I will-
Anup here.
Yes,
Inform
Anup.
sir to rejoin again and click the join with computer audio, this option. Hello, Rohit sir.
Yes, Anup?
Yeah, please inform the Puneet sir to join again and select the option join with computer and audio.
Tell me, I'll
Yeah.
write it.
Anup, problem here is sir is not able to hear us.
Sir, what do I need to write? I'm writing.
Sir, please send message through chat.
Already I have text.
No,
it,
please. No, you just start writing, madam, as you rightly said.
और संजय सर.
Madam, sir, whosoever is writing, please tell
आवाज
Puneet
बिल्कुल
sir.
नहीं आ रही मुझे एकदम.
हाँ.
Please log in again.
नहीं, शुरुआत में सुनाई दे रही थी, ऑडियो ऑप्शन किया मैंने,
We can
मगर
hear.
फिर भी मैं रिजॉइन करता हूँ. देखिए, चलिए.
Puneet sir, you are audible now.
Sir, you are audible now.
हाँ, मैं करता हूँ वापस,
अभी
लेकिन
सुनाई आ रहा है.
पहले
Recording no need, I think.
I think we have to pass the message to Sanjay sir now.
So
Because
Puneet sir has left the meeting. He is
I
relogging.
had
Kindly
words with him, and I told him to log out and relog in by clicking on the device
Sir,
option
he was
of
sir, he
audio.
was audible.
He was audible.
Then
He told me
Yeah.
that he joined. He could hear us, and
हाँ.
then फिर आवाज बंद हो गई उनकी.
नहीं, अभी उनकी आवाज आ रही थी सर आपसे बात करते समय.
अच्छा, okay.
Okay.
So he was speaking to me. I think he will rejoin again.
So I'm muting myself again then.
Yeah, please.
Okay.
Once sir joins and if he's audible, Rohit, you can take over.
Yeah, sir. I'm ready. I'm just waiting for him.
Puneet sir has joined.
Let us see whether he's audible now. Sir, can you hear us?
Yes, now I can hear you.
Yes, yes, sir.
But this is asking start my video. Should I do that or should I don't?
Yeah, yeah, please, sir, please. We need to see you, sir.
Now, is it okay?
Can we?
Now, can you see me?
Yes,
Yes,
sir.
sir.
Yes, sir.
Yeah.
Yes, sir.
Oh, Rohit, over to you, sir. Rohit,
Yeah.
over to you.
Thank you, sir. Thank you, sir. Welcome back again, Puneet, sir. And as you know that we are slowly getting acquainted to this new normal, what we call it in these days. And I hope these technical glitches over a period of time will be improvised in further webinars. So thanks again, everyone, for joining back. After initial glitches, let me start with today's webinar, which is Fundamental Rights Enumerated in Constitution of India by our eminent speaker, Shri Puneet Chaturvedi, sir. So, a brief introduction about Puneet Chaturvedi, sir. Meanwhile, I would request all the participants to please keep their phones on mute to get the full advantage about for today's informative webinar. Thank you so much. So, Shri Puneet Chaturvedi, sir, is a trained and practicing lawyer from a family of lawyers for 4 generations. Shri Puneet Chaturvedi has been practicing for the last 25 years and has argued several important matters before the Honorable Supreme Court of India. He has a remarkable distinction of having appeared and argued matters before almost all the high courts of India. Shri Puneet Chaturvedi, sir, is a scholar of Constitution of India as well as company and corporate laws. Sir has addressed several national and international conferences, and he has been awarded Best Speaker in Australia. He has also been teaching LLM to University of Mumbai and LLB to Government Law College Mumbai, besides being regularly invited by various other law colleges to conduct workshops on the Constitution of India, company law, criminal law, civil law of evidence, law of torts, law of contracts, Hindu law, etc. He is an expert on media law as well. Shri Puneet Chaturvedi has developed extremely lucid, practical, and pragmatic applications deriving from these laws, which he elucidates through his speeches, lectures, and workshops to let people understand easily what appears to be complicated provisions by applying these simple methods. He has also been appearing as a legal expert in different TV channels, including on NDTV and CNBC Awaaz. In addition to law, Shri Puneet Chaturvedi is a noted Vedic scholar. According to Shri Chaturvedi, he got mesmerized by this ancient scriptures as he found to be treasure of wisdom. He disclosed to the Ved and Vedanta are extremely popular because normally, sorry for the technical glitch, because normally his articles and speeches are widely heard. One can also watch and listen his legal as well as Vedantic speeches live on YouTube by simply typing his name, Puneet Chaturvedi Advocate, in YouTube search. Shri Puneet Chaturvedi is ably assisted by his wife, Srimati Rashmi Chaturvedi, who also happens to be an advocate. So with this, I would like to welcome sir on behalf of Rajshri Shahu College of Law. But before that, let me call upon our honorable principal sir, Advocate Sanjay Singh, to speak a few words about today's topic and about today's guest speaker. Over to you, Sanjay sir.
Good morning, everyone. Good morning, Advocate Shri Puneet Chaturvedi, sir, who is my mentor since last 7 years. At least 7 years, I've been knowing him since I'm there in the college. And he has been helping us by giving his... Can you please unmute the others? He has been helping us by accepting our invitations and coming to college and delivering his fantastic and wonderful lectures for 2 hours and hours together. He has also visited our college as a chief guest in our international intercollegiate moot court competition, and also the fest we have in our college. I will not take much time. I request Shri Chaturvedi sir to start the webinar on the fundamental rights enumerated in Constitution of India. He is a constitutional expert. I don't have any words on his ability, because is beyond my words. I don't have any words to express, what kind of, person, or what kind of, the personality Shri Chaturvedi sir is. Thank you very much, sir, for joining us. I request all of you to keep your phones on mute mode. Also, you can keep your phone on video off mode, so that the lecture goes on without any disturbance. Thank you very much.
Thank you, sir. Over to you, Puneet sir. Just for your information, we are streaming this video live also on YouTube, and of course on the Zoom as well. So request all the other participants to go on mute, please. We are about to begin the session. Over to you, Shri Puneet sir. Puneet sir, we are not able to hear you, and not even can see you now. Puneet sir, can you hear me? So I think we are not. There is still some concerns, some glitches. So kindly bear with us. We are trying to fix it. Sanjay sir,
Yes, Rohit.
can you please try his number again in case who has
I've
tried?
already sent a message to his number.
Okay, because we cannot see him either.
Rohit, if he is having problem through laptop, can you ask him to log in with the mobile only?
Okay. But earlier we were able to see and hear him. Just let me check.
मे बी उनकी ओर से नेटवर्क इशू भी हो सकता है.
Okay. Sanjay sir, did you get any response?
No, I'm still waiting for his response.
Sir, can you call him on his WhatsApp number, on the same WhatsApp, not from the landline?
Okay, I will call him. I don't know whether if I call him, whether I'll get disconnected from this. If I get disconnected, I may join again. I'll try to call him.
Yeah, no problem.
No, it says you cannot place a WhatsApp call if you're already on another call. So what I'll do, I'll exit from this and re-log in again.
Yes. Meanwhile, I request all the participants to put their videos in off mode only. It will help us to for the free flow of traffic, which is not possible due to congestion in network. So kindly remain on mute and put your videos off. Of course, other than the guest speaker and host.
Anup, can you hear me?
Yes, sir.
Sir has sir's broadband is got disconnected. He gave a call to the services also. They are saying that broadband is disconnected for 1 hour. Can you? I will send you his number. Can you assist him how to connect from the hotspot of the mobile to the laptop?
Yeah, sure.
Yeah, I'll send you. But I'll give you his number. Can you just take it down? 98210.
Just a moment, sir. 98.
210.
Okay.
10059. Can you please assist him?
Yeah, sure.
Yeah. Initially, we had problems of logging, and the other problem which has arisen is broadband got disconnected. So very unfortunate.
सर एक रिक्वेस्ट आहे, हे अनुपला विश्वकर्मा जो आहे ना, जो आता रेकॉर्डिंग करतोय, त्याला पुढचा पोर्शन सगळं डिलीट करायला सांगा.
Anup, we will restart the recording mode once sir joins again.
Yeah, you can stop. Correct.
त्यांचा नंबर पण आपण आता YouTube वरती जाणार आहात.
Yes, but he is very famous person.
नाही पण काही
recording delete karun, we will start the recording mode again once he joins.
Yeah, even we will you have to stop the live streaming of the video on YouTube as well. We will restart it again.
Yes.
Anup, if you can hear me, or Rajesh, if you can hear me.
Anup is assisting sir. Let him do that, and once he comes, we will restart it again.
Okay. Sanjay sir, if you are there,
yes.
Meantime, just to set up the tone and bring the.
We will stop.
Just a second. Bring the momentum. Yeah. Sir,
let me tell you, this is I think 6th or 7th webinar or seminar in the form, the first in the form of webinar, but I think 6th in the form of a seminar or in the form of a guest lecture we are going to have today. I've been associated with the Rajarsi Shahu College of Law since last 7 years, right from not 8 years, 2012 onwards. And I have one Dr. Pillai, who happened to be my friend, a dentist by profession. I used to visit him, and he introduced me with Advocate Puneet Chaturvedi ji. Once we met, I requested him to come to college and let's have a cup of tea and to guide some students. The very first lecture or guest lecture he conducted was amazing. Amazing means the batch is already out in 2016. They are practicing advocates today. But everyone, I think few of them might have joined in this also, because I have sent them the link also. And they will definitely confirm that whatever I'm saying with regards to those lectures conducted by Chaturvedi sir were amazing. The experience were amazing. His command on the subject, his command on the language, be it Hindi, be it English, Marathi to ज़्यादा नहीं बोल पाते sir, but फिर भी कोशिश करते रहते हैं बोलने की. But and the stamina, the energy, he reproduces energy. As the lecture goes on, his energy keeps increasing and increasing and increasing. So I have personally seen sir many times. Sir is a constitutional expert. Constitution के बारे में right from the making of Constitution. Sir has once delivered a lecture on making of Constitution. Such a wonderful lecture. I think we should also request sir to speak on that part also. Not today, because it will not be feasible to once the topic is given, or it will not be feasible for him, or the time will not permit to deliver a lecture on making of Constitution. Making of Constitution was such a lecture that many of us, even including me, didn't know 90% of the things which happened during making of Constitution. So we all should patiently listen to him once he joins. I think आज का जो technical error है, this has taken us about half an hour. Anup, can you hear me? Anup, are you there? I think Anup is on call.
Anup is on call.
Sanjay sir.
Anup is on call. Yes.
Sanjay sir, this is Professor Advocate Vijay Sharma.
Sir,
can I
good
say
morning,
something?
Sir.
Good
Yeah,
morning.
please,
Can
sir,
I
go
say
ahead.
something?
Yes, sir. Please go ahead.
I have known Puneet sir since long, and for him there is a share which I will quote, that वो हसरतों को तमाशा बनाए फिरता है, वो आरजुओं को तमाशा बनाए फिरता है, तुम्हें अंदाज ही नहीं है उसके कद का, वो यूं ही सर झुकाए फिरता है.
बहुत अच्छी बात है, बहुत अच्छा, बहुत बढ़िया सर.
This is Puneet
बहुत
sir.
अच्छी बात है पुनीत जी सर के लिए. He
And
deserves it.
yeah, he deserves it. I was working with him for a particular case. I think that was something that was related to a student or somewhere. And while working with him, I got sick, and he helped me. He dropped me near to the taxi.
Puneet sir, can you hear me?
Puneet sir, please unmute and please come on video.
हेलो,
Yes, sir.
मैं आपको सुन पा रहा हूँ.
सर वीडियो पे आ जाएंगे तो अच्छा रहेगा सर. Can you
हाँ, मैं
please?
कर रहा हूँ.
Yes.
जी सर आगे सर जी.
You can see me?
Yes,
Yes,
sir.
sir.
Yes, sir.
मैं first of all I apologize. The internet services have been disconnected, and I've just called my internet provider. He said that it will be reconnecting around 1 o'clock, and that is our closing time. So it was so unfortunate. In any case, let's begin with slight delays without wasting further time.
Yes,
Sure,
sir.
sir.
Please.
I hope all others can listen me.
Yes, sir.
sir.
Everyone
So,
can listen, sir. Please.
Just a meantime, when you were not there,
Alright.
last 10-15 minutes, we have already started the session, and we were actually discussing about your achievements and experiences of various professor over here with you in past years. And that is how we have utilized our time when you were not there. And now we are all set to listen to you, and it's over to you, sir, and stage is all yours. So this is a virtual stage right now we have. Over to you, sir. Puneet sir, can you hear me?
Hello?
Sir.
Hello?
Yes,
Yes.
sir. Yes, sir. We can hear you. Did you able to hear me, sir?
Yes, I can. Hello.
Right, sir. So over to you, sir. We are ready. Yeah.
Very well. So all the people who have joined today the webinar, I'm here first of all to apologize for this technical glitch, and let's begin without wasting any further time. First of all, I want to begin with the fact that the Constitution of India, when promulgated, had 22 parts and 395 articles. Whereas now, with almost more than a century of amendments, today it stands with 448 articles and 25 parts. But today, we are concerned only with part 3 of the Constitution of India, which is the most important part. Now, part 3 of the Constitution of India deals with the fundamental rights. So first of all, let me explain to you what is the meaning of fundamental. Fundamental means the basic, the essential, something which cannot be snatched by any other provision, and that is called fundamental. And if you remember, when in the year 1976, with the 42nd Amendment, wholesale amendments were conducted, and even the fundamental rights were suspended. You may be recalling ADM Jabalpur versus Shivakanta Shukla. Thereafter, when in the year later on, in Kesavananda Bharati, the Honorable Supreme Court had devised a basic structure doctrine under which the basic features of the Constitution of India cannot be changed. And therefore, the fundamental rights provided under Part 3 of the Constitution of India are irreplaceable as on today. Part 3 of the Constitution of India, which deals with Article 12 to Article 35, let's elaborate on each article one by one. So first, Article 12 deals with the definition of state. It says that state shall include the government of India, the government of each state, the Parliament of India, the legislative assemblies of each state, as well as the local government. Local government includes the elected corporators in a municipal corporation. Therefore, when we talk about the government, the definition of the government includes the central government, the state government, the local self-government, parliament, legislative assembly, etc. Then, moving ahead, we talk about the Article 13, which says that all the laws which were existing on the date of the commencement of the Constitution of India, as well as after the promulgation of the Constitution of India, the state shall not be able to make any law which is inconsistent with Part 3 of the Constitution of India, that is fundamental rights. To summarize once again, all the laws which were in existence on the date of the commencement of the Constitution of India, and if those laws were inconsistent to the fundamental rights, shall be, with immediate effect of the commencement of the Constitution in India, be declared as void. Further, Article 13 says that not only the laws prior to the Constitution of India, which were inconsistent with fundamental rights, shall be declared void, even in future. That means post commencement of the Constitution of India, the state shall not have any power to make any laws which would be inconsistent to the Constitution of India, specifically Part 3, fundamental rights. So this is the value added to the fundamental rights. That means they are essential. They cannot be revoked. They cannot be declared void. They are the basic feature of the Constitution of India. Every citizen of India has been given this wonderful power to have these basic rights within the Constitution of India. Now, subclause 3 of Article 13 says, subclause 3 of Article 13 declares that these provisions in respect of the laws declared above shall not apply to the amendments to the Constitution of India under Article 368. Thereafter, Part 2, subclause 2 of Article 13 gives the definition of law. That means what would be considered as law. So, the definition of law declares that all the ordinances issued by the President of India or the governor of each state, all the orders of the government, rules, regulations, bylaws, customs, or usage, everything would be law. Once again, I repeat, ordinances, orders, bylaws, rules, regulations, customs, usages, all are laws. Even the notifications issued by the government shall be laws as per subclause 2 of Article 13. So what is not law? It has covered almost everything. But still, please note two important judgments which had carved out that what would not be law. And incidentally, both the judgments of Honorable Supreme Court have clarified what is not within the definition of law given under subclause 2 of Article 13. First, the case of Union of India versus Naveen Jindal, AIR 2004 Supreme Court has held that the flag code is not the law within the ambit of subclause 2 of Article 13 of the Constitution of India. Therefore, flag code not being part of that law, which is featuring in Part 3 of the Constitution, the unfurling of the flag, which was regulated by certain provisions of law prior to that, was opened up. Now, as on today, you can unfurl national flag even on the top of your house. Only thing is, certain provisions which are under the flag code you would have to follow. The second important judgment is State of Kerala versus Chandramohan, AIR 2004, again Supreme Court. Both the judgments are of 2004. In State of Kerala versus Chandramohan, the Honorable Supreme Court has held that the circulars issued by the governments are not law within the ambit of Article 13, subclause 2 of the Constitution of India. So now, the situation as on today is that all the ordinances, orders, notifications, rules, regulations, bylaws, customs, usages are law, but not the circulars issued by the respective government, including central government and state governments, or union territory governments, or local self-governments. These circulars are not law, and the provisions of flag code is not law. So once again, I repeat these two judgments for those who want to note it. First, Union of India versus Naveen Jindal, AIR 2004 Supreme Court. And second, State of Kerala versus Chandramohan, again AIR 2004 Supreme Court. These two judgments are very important in respect of Article 13 of the Constitution of India. Moving ahead, Article 14, one of the most important and most commonly known article, which talks right of equality. Now in India, most of the people have a misconception that right of equality means everything is equal, or everybody in the society is equal. And this is why people try to misuse this provision stating everybody is equal. So let me tell you that that's not the case. It has been held by the Supreme Court that equality provided under Article 14 of the Constitution of India means equality among equals. It is not an absolute right. Equality is not an absolute right. When you read this article, the article itself clearly states that the state shall ensure that every person is equal in the eyes of law, and there is equality before law. So please understand the right perspective of equality. Equality means that you are equal in the eyes of law. Now, for example, if an offense has been committed by the lowest strata of the person or the highest strata of the person, the law would be applicable equally to both. I'll give you an example. Whether a red signal is crossed by a taxi driver or it is crossed by Ambani's, Tata's, or even the biggest of the highest of the high, the amount of penalty for breaching the signal would be the same to everybody. It will be equal in the eye of law. There won't be any discrimination as far as the application of law is concerned. If somebody breaches any provision of IPC or any other law which defines offenses, the punishments provided for that offense would be the same to everybody, whether you are a great industrialist, great professional, great businessman, or you are a simple laborer. That is the real meaning of right of equality given under Article 14 of the Constitution of India. That does not mean, that equality does not mean that I and the Prime Minister of India are equal. Sorry, we are not. As far as the stature is concerned, the status is concerned, certain privileges are concerned which are available to the Prime Minister of India, I cannot even claim them. Only thing is, what is equality is that the laws are concerned, the same law is applicable for me as well as to the Prime Minister of India. That is what is the true and real meaning of Article 14 of the Constitution of India. Now, moving ahead, Article 15 and 16. Two can be clubbed to understand together. Article 15 says that everybody, there won't be any discrimination between two persons by the law, and both the persons shall have equal opportunity. Now, Article 15 says that there shall not be any discrimination on the grounds of religion, race, caste, sex, and place of birth. Once again, I repeat, please remember 5 factors which are declared under Article 15, that there won't be any discrimination on these 5 grounds between the persons who are living in India or the citizen of India. First of all, religion. There won't be any discrimination whatever. There won't be any discrimination at all. Secondly, there won't be any discrimination between race, whichever race you belong to. There won't be any discrimination whichever caste you belong to. No discrimination whether you are a man or a woman or even a transgender. And lastly, whether you have born in Kanyakumari or Assam or Jammu and Kashmir, or whether you've born in the extremes of Kutch. In the remotest of remote corner of India, wherever you are born, you won't be discriminated on the basis of the place of birth. Now 16. I'm just going in conjoint with 15 and 16. 16 declares that there won't be any discrimination among these 5 factors for public employment. So, whether you belong to whatever religion, race, caste, sex, or place of birth, you would be entitled for all the public employment available. Only thing is, you should be qualified for that. You can compete for that. You can obtain that. There won't be any discrimination as far as the opportunity of the public employment is concerned. Now here, important thing to note in both the articles 15 and 16 is that there are sub-clauses. And these sub-clauses declare that the states are empowered to make special laws for the weaker section of the society. So despite the rule declaring that there won't be any discrimination, these articles are also not absolute. They are diluted by the sub-clauses themselves, which say that the state is empowered to make special laws for the weaker section of society. Now, who's the weaker section? Weaker section is women, children, scheduled caste, scheduled tribes, and other backward classes of the society. Now here, important to notice that in 2019, by 103rd Amendment of the Constitution of India, one more qualification has been added. 103rd Amendment of the Constitution of India, 2019. By amendment, another weaker section has been introduced, that those who are economically backward, a new provision has been carved out. Economically backward belonging to whichever class, whichever caste, they shall have, a state has the power to make special laws for them also. And therefore, in addition to the classes which I said, women, children, scheduled castes, scheduled tribes, other backward classes, now economically weaker classes have also been added. And not exceeding 10% has been added, that over and above whatever has been provided, a 10% opportunity shall go to those who belong to economically weaker class. Now moving ahead, these are 15 and 16. Articles 17 and 18 can be clubbed together like we clubbed 15 and 16. Articles 17 and 18 abolish two things which were prevalent prior to the promulgation of the Constitution of India, and they were abolished by Article 17 and 18. Article 17 abolished untouchability. It declares that with the commencement of the Constitution of India, the state shall ensure that there shall not be any untouchability. And all the persons, whoever belong or reside in India, there should not be any practice of untouchability. Now, like 15 says, there won't be any discrimination among the citizens of India. Article 15 itself, because 17 is supplement to 15, which says that all the persons of India will not be disqualified to take advantage of, or they can go or enter in any shop, any restaurant, any place of worship or dwelling house. Nobody shall be prohibited only on the ground that the person belongs to some religion, caste, sex, race, place of birth. Similarly, no person shall be deprived of using any well, river ghat, road, public facility on the basis of religion, race, caste, sex, place of birth. And to supplement all this, Article 17 says, nobody shall practice untouchability. Now, please understand the perspective of Article 15 conjoining with Article 17. 15 clearly stated that those practices where some section of the society was deprived from using well or river ghats or public road, etc., or they were prohibited from entering into a particular place like shop or restaurant or place of worship. Now all that had been abolished. So Article 15 and 17 both are important. Article 18 abolished to further supplement Article 15 and 16. Again, 18 is important because 18 abolished all the titles. Now, titles means you may have read in the books that during British time, certain distinguished class of the society was honored by giving titles or bestowing titles on them. For example, what we commonly use in today's colloquial language, addressing each other as sir. Sir is a title given by Britishers, and very few distinguished people were bestowed by this title called sir. So not everybody could have used this title so colloquially and commonly, which we use today. You might have heard there used to be barons, there used to be knights, and some of the Indian kings were given the titles of Rai Bahadur. These kind of titles, which were bestowed prior to the promulgation of the Constitution of India, were all removed. They were abolished. Not only abolished, but there is a prohibition you will find under Article 18 that nobody can accept any title even if it is bestowed by a foreign government to you. If you're a citizen of India and a foreign government bestows any title on you, you cannot accept it. So another very colloquially using word is, which we use very commonly, and that is lords. In courts, we call the judges as lords. Lord is also a title, which is quite commonly given in the British countries even today. In Great Britain, people are bestowed with the title of Sir, Baron, Knight, Lord, etc. But if you're an Indian citizen, even if some title is bestowed upon you, there is a prohibition for even accepting that. But there, again, Article 18 is not absolute. There are certain exceptions carved out. That means certain titles can be used even as on today in Indian post-constitutional society. For example, the armed forces titles are bestowed and used even today. So the titles of the armed forces are usable and acceptable, and they cannot be violating the provisions of Article 18 of the Constitution of India. Second, the educational titles are prevalent. They are not prohibited. For example, if you have done a PhD, you are bestowed a title of doctor and which you can use it. So the titles belonging to armed forces and the titles belonging to the educational sector are exception to Article 18. Rest all the titles are abolished. Now, moving ahead, we reach to Article 19, another very important article in Fundamental Rights, Part 3 of the Constitution of India. Article 19 deals with freedoms provided to the citizens of India. Mind you, Article 19 is available only to the citizens of India. Now, Article 19 gives a right of 6 freedoms, which are provided under Article 19, subclause 1. 19, subclause 1 gives 6 rights of freedom from Article 19(1)(a) to 19(1)(g). Now, G makes it 7, but because Article 19(1)(f) has been deleted, therefore, there remains only 6 freedoms. Article 19(1)(a) gives the right of freedom of speech and expression. In today's India, the most used and the most misused article, if I can say, because most of the anti-national statements, the people who make it under a defense of the right of freedom given under Article 19(1)(a) of the Constitution of India, which says that every citizen of India has the right of freedom of speech and expression. Now, mind you, those who are doing so are under misconception, because even the freedoms provided under Article 19(1), all those 6 freedoms are not absolute. They have restrictions provided under Article 19(2) to 19(6). So first of all, let us have those 6 freedoms. As I said, Article 19(1)(a) deals with right of freedom of speech and expression. Article 19(1)(b) talks about the right of freedom of having a peaceful assembly. That means, please remember here, CRPC, because it is relevant. Under Article 141, under Section 141 of CRPC, there is a definition of unlawful assembly. An unlawful assembly and committing a crime with a common object of unlawful assembly is punishable offense, and the punishment is there under Section 149. I'm sorry, I had said CRPC. Please pardon me. It is IPC. 141 of the IPC read with 149 of the IPC, which defines unlawful assembly. because offenses are defined in the substantive law of IPC. So, IPC defines unlawful assembly vis-a-vis the Constitution of India under Article 19(1)(b) says peaceful assembly. So there is a distinction. That means one can have a peaceful assembly as a matter of right, and everybody has a freedom to have a peaceful assembly. So that is why nobody can disturb if you are having an assembly of wedding or for any occasion or for any function, birthday party, whatever. So that peaceful assembly is your right of freedom given under Article 19(1)(b). Then comes Article 19(1)(c), which talks about the right of freedom to form associations. Every citizen of India is entitled to form associations, including cooperative societies. So that gives that privilege that anybody wants to make a club or to kind of have a form an association, a body of persons or cooperative society or a team. All that is your right guaranteed under Article 19(1)(c) of the Constitution of India. It's your fundamental right. Nobody can snatch it unless you're having an unlawful assembly, which is prohibited. Well, moving ahead, Article 19(1)(d) gives another freedom, a right of freedom to move freely across the territory of India. You have every right to reach, to move, to travel, to go anywhere in the country, wherever, to whatever point the territories of India extend. That movement, the free movement, is your fundamental right guaranteed under Article 19(1)(d) of the Constitution of India. You don't need to have a passport or a visa to move or to go anywhere. You can move easily. Only qualification requires is that you must be a citizen of India. That's it. There are certain states who have permit system, that if you want to visit that state, you need to have a permit. But permit is different than visa, because permit does not require as a precondition of a passport. Visa is granted by a passport. Permit is simply a kind of roll call where the state wants to know whoever is visiting that area. That's it. Now, for example, if you want to go to any other area of India, which does not even require permit, you can move freely. But certain states like Arunachal and all, they require your permit because they have to have a roll call. But for that, obtaining that permit also, you don't need to have a passport. Moving ahead, Article 19(1)(e), another important article, which gives you the freedom and the privilege to reside in any part of the territory of India. Wherever you choose to reside, you can go and reside. Now, here again, there are certain states which have made certain laws. And therefore, I said that these freedoms are not absolute. There are restrictions provided from Article 19(2) to 19(6). And the last, an important article, is that 19(1)(g), which says that whatever profession, occupation, trade, or business you want to do, you are entitled to do. Nobody can stop you from that. Now, here again, please remember that there are certain qualifications which are required to do certain professions. So this freedom does not mean that it is an absolute freedom, and even if you're not qualified, you can start doing that profession. If you want to become a lawyer, you must be enrolled with the Bar Council of India after getting a degree of law. If you want to practice medicine, you must be MBBS and enrolled with the Medical Council of India. There are certain qualifications provided. So if there are certain technical requirements and qualifications for practicing certain professions, trades, or business, then you must have to follow that. As I right in the beginning said, that these freedoms are not absolute. Moving ahead, Article 19 gives you these rights of freedom, these 6 rights of freedom. Article 20 gives you protection from unlawful conviction. Now, please remember, when I say unlawful conviction means that Article 20 says that if you have committed an offense by breaching any statute or law as on the day in force, then only you can be punished for that offense. That means nobody can be punished for an offense which is not in force on the day of the offense. You might have observed, pardon me for a moment. We all recall a very unfortunate incident happened in December 2012 on the streets of Delhi, which was commonly known as Nirbhaya case. Among the accused, it was found that one of the accused was juvenile, and the age of the offender was below 18. And therefore, he was not punished in accordance with the regular law of India. Rather, he was tried under juvenile justice system. Everybody was very upset. And therefore, as a consequence, the government had appointed J.S. Verma committee to revisit the criminal laws. And after J.S. Verma's committee's report, wholesale amendments were done in respect of sexual offenses against women. But because these amendments came later than the date of the offense, due to Article 20, subclause 1, that offender could not have been punished after the amended law, because Article 20, subclause 1 says and declares that a person can be punished only and only within the law in force as on the date of the offense. So definitely after the amendments, if the same or similar kind of an incident happens as on today, now the punishment would be different because the age limit had been brought down from 18 to 16. Second important doctrine under Article 20 is that nobody shall be punished twice for the same offense. The doctrine of double jeopardy. The doctrine of double jeopardy is involved under Article 20, subclause 2 of the Constitution of India. Nobody can be punished twice for the same offense. And the third doctrine under Article 20 of the Constitution of India is that nobody shall be compelled to give or to be a witness against oneself. That is doctrine of prevention of self-incrimination. Doctrine of prevention of self-incrimination declares that nobody shall be compelled to give evidence or be a witness against oneself. That, please understand, that does not mean that one cannot be. Please understand or remember Section 25 of the Indian Evidence Act, where one can make a confession and state that I have committed this offense or I have committed this crime. So there's no bar, but there is a prevention against compulsion. Article 20, subclause 3 says that you cannot be compelled to be a witness against yourself, or you cannot be compelled to give evidence against yourself. If you voluntarily want to do that, that's your choice. And that is why a confession given to police officer, even under Indian Evidence Act, is not an admissible evidence. One has to give a statement of confession to a magistrate. And that confession statement to a magistrate is treated under section 164 of the CRPC. So please remember these sections along with these articles so you can understand the law in the right perspective, because it's a comprehensive understanding. Otherwise, you would find or you would believe that there are contradictions, because there are no such contradictions taken. Things have to be understood in the right perspective. Now, moving ahead, another most important article of the Constitution of India is Article 21. Article 21 deals with life and liberty, the right of life and liberty. Now, here, I pause for a moment to make you take a note of the fact that as against Article 19's freedom, Article 20 is applicable and provided to all the persons of India. Article 19 as against 21 had given those right of freedoms only to the citizens of India. Article 19 is not entertained, cannot be entertained, or is not available to non-citizens of India. Article 19's 6 freedoms are available only and only to the citizens of India. Whereas Article 21, the right of life and liberty, is provided to every person, whether you are a citizen or even a non-citizen, simply a tourist to India, or you're visiting India, or you're a resident of India because of some employment. The Article 21 is guaranteed to you as well, even if you are a citizen or non-citizen of India. Now, Article 21 also has a proviso attached to the main article itself. It looks to be one-liner, innocuous kind of an article, but a very important article. Every person is entitled to life and liberty, and the state cannot snatch it other than the procedure prescribed by law. That means if you violate any law promulgated by the parliament or state legislatures, then your life and liberty can be snatched by the state. So again, even this right is not absolute. If you are a follower of law, if you are following the law in the right spirit, then only this privilege is provided to any person, whether you are citizen or visitor. But if you violate the law of India, then the state can snatch your life as well as liberty as per the procedure prescribed by law. And that means the state can make you imprisoned. The imprisonment is your liberty being curtailed. And the state can hang you till death under death penalty. That is where the state can snatch your life also. So the punishments of death sentence, life sentence, or imprisonments find place vis-a-vis Article 21 guaranteeing your life and liberty. Because if you violate the law, this life and liberty is not an absolute right. So that is where even a visitor, if commits an offense, his liberty can be curtailed. His life can be snatched. Now, there are certain very important judgments under Article 21 which we must take a note of. Because this article looks very innocuous, one-liner. But the meaning of life has been snatched to a different level by various judgments of the Supreme Court of India. Because if we ask what is life, most of the people would answer that if we are breathing, if we are having a life in our body, then it is life. But that is not the true meaning of life. Life does not mean survival. Life means living. Life does not mean living like an animal. Life means living with dignity. Dignity which behoves to a human being. And that is where the meaning of life have been stretched to different levels. An important judgment of Bandhua Mukti Morcha, AIR 1982 Supreme Court, which is also known as Asiad Labour Case. The Supreme Court has held that a right of a woman to take bath in privacy is her right to life. In Olga Tellis versus Bombay Municipal Corporation, the Supreme Court has said a person who has been living in hutments, encroaching upon the land of the government, but living beyond the period of time prescribed, and the corporation has not vigilantly prohibited that, then the corporation cannot remove that encroacher without giving notice to him, because that is also his right to life. You cannot remove his life all of the sudden on one fine morning when you wake up. Similarly, in MC Mehta versus Union of India, right to breathe fresh air is a right to life. So, the polluting industries were removed from within the municipal areas of every city, because fresh air is a right to life. Fresh and therefore fresh potable drinking water is an obligation of the state within Article 21 of the Constitution of India. Now, these are vital judgments. Even a right to travel abroad, as held in Menaka Gandhi versus Union of India, 1978 Supreme Court. Right to life. Therefore, a right to life is a very important article under the Constitution of India. Moving ahead, Article 22, another fundamental right. Article 22 says that no person shall be detained without following the procedure of law. That means, even if a police arrests or detains any person, then he has to inform the nearest magistrate within 24 hours of that detention, excluding the time of traveling. This is fundamental right given under Article 22 of the Constitution of India. Nobody shall be detained for more than 24 hours without having an authority or an approval by a judicial magistrate. Now remember here, Article 22 must be read with Section 57, read with Section 167 of CRPC. Mind you, Section 57 of the CRPC says the same thing, that nobody can be detained by the police or kept under the custody beyond 24 hours without the approval of a judicial magistrate, and in the absence of a judicial magistrate, with the approval of the executive magistrate. And the powers of remanding a person in the police custody, the maximum by the judicial magistrate can be for 15 days and by the executive magistrate for 7 days. So these are the provisions which you must remember while reading Article 22. Section 57 read with Section 167 of CRPC. Now moving ahead, Article 23 and 24 deals with right against exploitation. So I'm clubbing these two articles, 23 and 24. Article 23 deals with bonded labor, a prohibition against the forced labor or a bonded labor or a bandhua majdoor. As we all know that prior to the Constitution of India, there was a prevalent practice of slavery. To overcome, to stop that malified practice, Article 23 is being given as a fundamental right of every citizen of India. The prohibition against bonded labor, forced labor, slavery is named as there is a bar on human trafficking. The word used is human trafficking. Now if you want to use a labor, then you would have to compensate the labor as per the remuneration and consideration which the labor deserves. Therefore, Article 23 prohibited the practices of bonded labor, forced labor, slavery, bandhua majdoor. Similarly, Article 24 prohibits child labor. Nobody can force a child to work in a factory, mine, or hazardous employment. Please remember, factory, mine, or hazardous industry, child labors are prohibited. That means nobody can employ a child in these industries. There is a constitutional fundamental bar against that. And not to be employed in these industries is a fundamental right of every child. Like not to be a bonded labor or a forced labor is a fundamental right of every person who's in India, every citizen of India. Nobody can force. If you're forcing and if he complains, the state shall come to his rescue. And that is Article 23 and 24 for you. Moving ahead. Article 25 to 28. 25 to 28 can be clubbed as fundamental right of religion. Fundamental right of religion. Article 25 makes a declaration. Here I stop you to please revise and get reminded of the preamble of the Constitution of India, which declares, we the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic. Now the secular word belongs to state, that India as a state is secular. But those who are living in India, the persons who are living in India, they can follow religion of their choice. So please understand that the mandate of secularism does not apply to the people living. There is no religion of the state. There is no religion of the government of India. And government of India views all the religions as equal, treats all the religions as equal, as per the mandate of the Constitution of India, as declared in the preamble. Although the words socialist and secular were added much later by 42nd Amendment of the Constitution of India, prior to that, the very feel of the Constitution of India had been very vocal that the Constitution or the government of India is secular. There was no need to add these words, but they were added because the wholesale amendments were done in the Constitution of India by 42nd Amendment in the year 1976. Moving ahead. Article 26 gives the privilege to put any institution of your choice. Like 25 says that you have not only the privilege and the right to practice, profess, and propagate your religion, you can establish any institution under Article 26. 27 says that you can obtain land to establish any institution to propagate, to profess, to practice your religion. And Article 28 says that the government of India shall not levy any special tax and appropriate that tax amount in furtherance of any religion. So there won't be any special tax for propagation of any religion. It is a choice of every citizen and every person of India to follow the religion, to profess the religion, to practice the religion, and to propagate the religion as per their own choice. Here again, a religion cannot be forced upon anybody, because in the eye of state or the government of India, all religions are equal. So there is no religion of the government of India as enshrined from Article 25 to 28 of the Constitution of India. Now, moving ahead, there are two articles, Article 29 and Article 30, which can also be clubbed together. Article 29 and Article 30 talks about education. These two articles give right to all the minorities living in India to establish the institution to propagate their own culture. Article 29 talks the minorities on the basis of language, on the basis of culture, on the basis of script, whereas Article 30 also gives a qualification of being minor on the basis of religion also. So there is a difference between Article 29 and 30. 29 talks minorities on the basis of region, language, script, culture, whereas Article 30 also includes religion as a basis of minority and gives privilege to establish their institutions, to propagate and to follow and to profess and to practice the choice of their religion or their language or their script or their culture. Now, what is important to note over here is that even these two articles have provisos, because these two articles are not absolute. They say that everybody has these rights from 25 to 28 to profess, propagate their religion, practice, profess, propagate, and 29 and 30 gives the special right to the minorities. But the provisos are that the state can make law to regulate these provisions. The state can make law to put curbs on these provisions given under Article 25 to 28 and 29 to 30. That means that first, these rights should not be absolute, treated absolute. They are subject to public health, public good, morality, and health. So, your practice, profession, and propagation of religion shall not be treated as absolute. They are subject to public good, morality, and health, and other conditions also. So if the government or the state feels that these provisions are being misused, the state can make laws to curb them. Further, another important factor is that if any of these institutions or education institutions by the minorities are aided by the government or using the help of the state or funds of the state, then they are available to every citizen of India, not limited to that small section or minority section, whether it is on the minority on the basis of language, script, culture, or religion. So these are the provisos to these articles. Now, Article 31 is deleted. Instead, 3 articles were added, Article 31A, 31B, 31C. And there are various judgments putting curbs on these articles. Right from Keswananda Bharati to Minerva Mills, you'll find that when the then government tried to steamroll the judiciary by bringing these laws and amending the Constitution of India by bringing these articles under Article 31A, B, and C. And the basic purpose was to circumvent the judicial review of the laws made by the parliament. It was an attempt to create a supremacy of the parliament on the Supreme Court of India. But that did not work. And these provisions were time and again by various judgments diluted. Then comes the most important provision, which in my personal opinion, the most important under Part 3 of the Constitution of India is Article 32. Why I say most important is because the entire Part 3 would be useless if there is no Article 32. Because Article 32 instills power into every citizen of India. One individual, by this article, gets immense power to even shake up the entire government, to get the laws passed by the parliament set aside and quashed. This is the power of Article 32. One does not need any association or a body of persons or even a political party to support you. One single individual can stand up and make a statement that this is not done. If he has this objection to any act of parliament or any act passed by any legislative assembly of the states, which is unconstitutional, which is against the provisions of law or fundamental rights provided under Article 32 of the Constitution of India, one man can stand up and challenge it under Article 32. And it is aptly named fundamental right of remedy. If Article 12 to Article 30 are your fundamental rights, substantive rights, then Article 32 is your fundamental remedy to invoke those rights if anybody dares to violate those rights. Article 32 says that if any person feels that his rights provided under Part 3 of the Constitution of India are violated, he is entitled to move directly the Supreme Court of India, the highest court of India, directly, without going to the subordinate courts or even to high courts. One is entitled, if one's fundamental rights are breached, one can straight away go to the Supreme Court of India and put his grievance against the breach and violation of his fundamental rights by filing a writ in 5 categories. There are 5 categories of writs provided under Article 32. The writ of habeas corpus, certiorari, quo warranto, prohibition, and mandamus. I repeat, writ of certiorari, mandamus, quo warranto, prohibition, and habeas corpus. 5 writs. By any of these 5 writs, one can move the Supreme Court of India, challenging the breach of his or her fundamental rights. And mind you, with further evolution of law, with the lapse of time from the date of the promulgation of the Constitution of India, as on today, this Article 32 right is expanded further. Now, even one whose rights are violated need not to move the Supreme Court. Somebody else on his behalf can move Supreme Court. Because the Supreme Court felt that the doctrine of locus standi does not belong or cannot curb the right given under Article 32. So therefore, Supreme Court itself expanded the power of 32. Doctrine of locus standi does not apply in the narrow sense under the provisions of Article 32. That means if your fundamental rights are breached and you're not capable to move Supreme Court of India, somebody else can also move Supreme Court of India on your behalf on the violation of your fundamental rights. And that concept is called public interest litigation, PIL, where enlightened persons can move Supreme Court of India, putting a grievance of violation of fundamental rights of other citizens of India. So therefore, these judgments which I talked about, like Bandhua Mukti Morcha or Olga Tellis versus Bombay Municipal Corporation, they were PILs, public interest litigation. Some enlightened citizen found the violation of fundamental rights. For example, if we talk about Bandhua Mukti Morcha, where a great theory has been propounded that the right of a lady to take bath in privacy is her fundamental right of right to life, was propounded how? For example, what had happened, the facts of the case was that one journalist was passing. The incident had happened in Delhi, where India was preparing to organize Asiad Games. India had competed to bid for Asian Games and successfully got it. But India was not prepared at that time. If you remember, or most of you may not have been born at that time, 1982, India held Asian Games, which was called Asiad. At that time, the location of Asiad was chosen to be Delhi. But unfortunately, even Delhi did not have the preparation to hold such large-scale sports. So it was decided to prepare the stadiums, to prepare the places for those sportsmen who were becoming, where would they be staying. So those preparations began on large scale. And even if you go to Delhi today, there is a whole place called Khelgaon. That Khelgaon was constructed for Asiad prior to 1982. For this large-scale construction, laborers were needed. And Delhi did not have that number of laborers, so laborers were migrated from all parts of India to Delhi. Now, those laborers who had come to India, to Delhi, to prepare Khelgaon or stadiums for the place of living for those sportsmen who would be coming. Now, where would these laborers be accommodated was the question mark. Because they are the ones who are going to construct accommodations. But even when they had come, their accommodation were also required. So for that, what was done was, on huge fields, tents were put. And temporary water connection lines were put. Temporary electricity connections were put. And in tents, those laborers were placed. One day, a journalist who was passing through saw a very ironical activity. What was watched was that before every tent, there were certain laborers who were preparing food. There, certain children were playing in the same area, and some public taps were fitted in between 10 tents or 5 tents, suppose. And on those public taps, which were the only source of water, drinking water was also being taken, and people were taking bath in open, including women, because there's no other place where water was available. So on this public tap, which was put among 5-10 tents, food was prepared, children were playing, people were taking bath, even women were taking bath in open. So this journalist clicked some pictures, purchased a 15 paisa postcard. 15 paisa was the cost of the postcard at that time, and wrote a letter, stapled those photographs, and sent it across to several authorities, including President of India, Prime Minister of India, and Supreme Court. Supreme Court and converted that postcard into a petition under Article 32 of the Constitution of India. Those photographs were taken as exhibits to that petition, and the notices were issued to the government of India as to whether that the laborers who have been brought from various parts of India to Delhi, are they not the citizens of India? The question posed was, in the notices issued by the Supreme Court of India to the central government, whether these laborers are not entitled to the fundamental rights provided under Part 3 of the Constitution of India. Are they not citizens of India? And the ironical part is that the reply submitted by the central government was playing very innocent, as if, what have we done? We have provided them shelter in tents. We have provided them water through taps. We have provided them electricity. We are giving them their due remuneration. So where is the question of exploitation? And it is here when the Supreme Court had held that what about these photographs where women are taking bath in open public gauge? And that is where Article 21's definition was enhanced, that a woman's privacy is, in her privacy lies her dignity. And in her dignity lies her life. A life without dignity is no life. And it is in this judgment the concept is that life does not mean survival. Life means living. Living means living human life. And human life is different from animal life. Human life means living with dignity. And therefore, the meaning of life was expanded, but invoking what? Article 32. Similarly, in Bombay Municipal Corporation, Olga Tellis versus Bombay Municipal Corporation, 1986 Supreme Court, a journalist saw that BMC was removing encroachment one fine day. And it was found out that the people were crying. Their goods, their
articles of home were thrown, their huts were crushed under bulldozer. And similarly, certain photographs were clicked by Olga Tellis, annexing into the photograph a postcard. She sent it to the Supreme Court. And the Supreme Court has held that those people who were living at that encroached place for more than 20 years, is it not the responsibility of the Bombay Municipal Corporation to protect the governmental land? How had they allowed these people to encroach at the first place? And suppose if they encroached, how are they allowed to live for 20 and more years? And one fine morning, if you wake up for your right and come to demolish, first, you must feel guilty that you did not follow your duties in the right spirit. And therefore, you should be penalized, not those encroachers. And it is there in Olga Tellis versus Bombay Municipal Corporation, the Supreme Court has held that first, you will have to provide alternative accommodation, then only you can remove encroachers. So these are the landmark judgments which have changed the destiny of the citizens of India, which has given that spatial privilege, the meaning of article of right of life, etc., right of freedoms, etc. Excuse me for a moment. And that is why I say Article 32 is one of the most important articles, because it is this article which provides a remedy to all other fundamental rights. If your latest case of freedom of speech and expression, which was misused, even there, Article 32 came into rescue. Whether the freedoms provided under Article 19, if there is a violation, where will you go? Your rescue point is Article 32. Moving ahead, Article 33 and 34 again can be clubbed, because these fundamental rights provided under Article 12 to 30, as I said, they are not absolute. 33 and 34 says that the state can make laws to create exceptions to the fundamental rights in respect of armed forces, or those forces who are invoked for public duty. That means armed forces and forces working for public duty may not have these fundamental rights in totality for themselves, and there can be certain curbs which can be imposed, certain restrictions which can be imposed by the central government. For example, Article 19(1)(b) gives a right of freedom to make association. 1(c) make a freedom of right of freedom to make associations or body of persons or clubs or unions. But can this privilege be given to armed forces? Have you ever heard of army making some union and raising voice against the government of India or going for strike? So there are certain privileges which are prohibited, and the state was given power under Article 33 to make special laws in respect of these armed forces, etc. Similarly, Article 34 says that this lawmaking power in respect of armed forces is limited only and only to the Parliament of India. State legislatures are not entitled to make laws. Next, Parliament, Article 34, can also curb these fundamental rights, put restrictions on these fundamental rights in any portion, territory, or locality of India where martial law is applicable for that time period. So the period on which a martial law is applicable, then these fundamental rights can be curbed and restricted under Article 34 by the Parliament. And you might have heard about APSA, Armed Forces Special Rights Act. And that is the law made by the Parliament under Article 34 of the Constitution of India. And then comes Article 35. Article 35 says that the privileges and the laws to be made are only the privilege and right of Parliament, and nobody else can do that. And this sums it up from 12 to 35, your part 3 of the Constitution of India, which talks about the fundamental rights and the fundamental remedy. I had tried to give you a comprehensive picture of the fundamental rights vis-a-vis the statutory provisions lying under various statutes like IPC, CRPC, etc., wherever the relevant provisions are invoked. I've tried to enlighten you on various judgments on various articles relevant to those articles, to fundamental rights in the provisions of the Constitution of India. And most important thing is that the judgments which had declared that these fundamental rights find place in the basic structure of the Constitution of India, and therefore they are irreplaceable. Constitution of India can be amended under Article 368 of the Constitution of India, but fundamental rights are irreplaceable. Before I leave, I just want to make one more declaration that those of you who want to get more information and more knowledge in respect of the Constitution of India or in respect of other rights or other laws, you can visit my YouTube channel by simply searching Puneet Chaturvedi Advocate, P-U-N-E-E-T Puneet, Puneet Chaturvedi Advocate. Subscribe that channel and you will get notifications about all my speeches, not only on the Constitution of India, on various laws, and you can enlighten yourself. In case if you have still further queries about any law, including the Constitution of India, you can put your queries and mail it to me. You would be answered that query on the email. Please note SCC Advocates, S for Singapore, C for China, sccadvocates@gmail.com. And if you want to have a verbal communication with me, please note my phone number 98210-10059. Feel free to call, feel free to question, and all the answers and queries would be provided to you as quickly as possible, either by myself or by my team. Thank you so much. Jai Hind.
Thank you, sir.
Thank you very much, Puneet sir. It was really a very informative and it's like a mind refresher for us, for all of us as a students. We really appreciate the way you have explained it to us, the Constitution of India. I think it will remember forever in our mind, because the flow that you have got and the command you have your voice when you explain. So we can actually imagine maybe if we will be fortunate enough to see you how you argue in the Honorable Supreme Court of India or in any other court. It will be much to delight us. So with this, I think the session for question and answer is there. So I would like to invite Mr. Rajesh ji and Sanjay Singh sir to please handle the question and answer session. Over to you, sir.
Thanks a lot again, Puneet sir. Again, a centurion performance. I'm, sir, I was having the idea what kind of performance will it be, but I think my students are more delighted to see you, and we would like to see you again and again and again, and that again never end. Will never end, sir. I assure you, sir. Will it be feasible now for you to answer the questions, or should I call my students to give you an email of the questions and it will be answered? Will it be feasible
Sure,
now,
thank
sir?
you. Anytime.
So will it be
Anytime,
feasible?
most welcome.
Right, sir. Right, sir. So I request all the students who have questions on today's webinar to send an email to Puneet Chaturvedi sir, and your questions will be replied.
You can put. Hello.
Yes, sir.
You can put this my email ID also on your chat. S for Singapore, C for Calcutta, again C for Calcutta, SCC Advocates, ADVOCATES, ending with S at ccadvocates@gmail.com.
I have taken a note of it.
And you can put my phone number also,
Yes,
98210-10059. And
Right,
please remind them if they want to have more such speeches, they can visit my YouTube site also.
I have already gave the instructions, sir.
Yeah.
The Puneet
And whenever you want, on whichever subject, you're most welcome. I'll be honored to address you all again. And I'm really sorry for this technical hitch in the beginning.
So before you leave, let me tell you, sir, before you joined in the group, I was telling my students about the session you conducted for making of Constitution. And
yes,
we would like
I remember that.
Sir, we would like to have that session again in whenever you in your
wonderful,
free time,
definitely.
Sir. That was a wonderful session.
Sure.
I still remember.
Sure.
I told them that 90% of the things I was also not aware, which Puneet sir told us.
No, I'll definitely do it whenever you say. And whatever subject also, if you want to conduct webinars, let me know. We'll conduct webinars for all the subjects, whatever you want for your students.
Right, sir. Right, sir.
Thank you so much.
Over to Kailash sir. Kailash sir want to speak something because he was there as a student. Now he has joined as a lecturer to us. So he would like
lovely.
to
Congratulations.
Thank you very much.
Sure,
sir.
Congratulations, definitely.
It is not only a pleasure but an honor to attend.
I know Kailash. I remember him very well.
Thank you very much. Sir.
Yes, Kailash.
Sir, big thank you to you for spending such precious time of yours with us and sharing your views on Constitution. It is indeed, as I told, it is not only a pleasure but honor to attend your lectures. And as the other students have said that it would be indeed an honor to actually see you arguing in the court. I have already met you in High Court and spoken to you and met you there. But the students would be more excited to see you in the court. But indeed, a big thank you to you for spending your precious time in this pandemic situation also, and giving us the opportunity to listen to your views and get enlightened by the knowledge that you have. I also take this opportunity to thank our principal advocate Sanjay Singh sir to give us
Thank you, Kailash.
Give us a chance.
Thank you so much.
Yes, sir.
Unfortunately, now you will have to listen to me my arguments in the court through video conferencing only because the courts are now working only video. and during this lockdown also argued certain matters through video conferencing only.
Yes, sir. Yes, sir.
Thank you so much once again.
Thank you. Thank you. I also take this opportunity to thank our principal advocate Sanjay Singh sir for arranging such kind of webinars to enlighten the students. And also a big thank you to all the students who joined us in this seminar. More than 160, 170 students had joined this seminar and took experience of this enlightenment over the constitution. I thank all the students. Thank you very much. Thank you to all the hosts for letting us get in to this webinar, and thank you for the facilities that you all provided. Thank you, all of you.
Thank you. Can I leave now?
Thank you. Yes, sir. Thank you so much, sir. Thank you so much.
sir.
I request everyone to remain online except sir,
Okay.
sir, to have a photograph. To have a photograph on video, please. Host, I think Anup can click photographs and then people can leave.
So we request everybody to come on video, please.
Everyone, please come on video. Rajesh ji, is photograph being clicked? Please acknowledge either Anup or Rajesh ji or Rohit.
All are requested to please come on video so that the photo is to be clicked.
Yeah. Let me see. Rajesh ji, are you there? Rajesh ji, Anup, anyone?
Chiva, I am taking a photographs. Please be on.
Okay.
It will take
Yes,
up 1
yes.
minute.
No problem.
He's taking.
Meanwhile,
He's taking.
Yeah, sure. So meanwhile, the picture has been clicked. I would like to thank all the students and fellow students, my seniors, and of course the professors who are attended this conference. So today's session has already also taught us that despite coronavirus, despite there are so many technical glitches, but now we are getting used to this new normal, and I think with the this kind of quality sessions, it will definitely going to help us to add more and more knowledge and value the way it has been taught to us by Puneet sir. Although we are missing the classes, but the knowledge is not missing. That is what I can say. And I would request Sanjay sir to please give us what we can expect more in the coming days.
Definitely, I'm planning on it also. Uh, I would like to thank Advocate Vijay Sharma ji, if he's there still with us, to share the. I think Vijay Sharma sir has left. Okay. So we will have many more such sessions. As I have already told Puneet sir also, I have also in conversation with some other eminent speakers also, to have them with us for some subjects like CRPC or any other subject which is beneficial for us, or any practical topics or on lockdown. So I thank everyone to join the wonderful webinar being conducted today. And I am very thankful to Mr. Rajesh Tokleji, who has supported his platform, and his team, Mr. Anup Vishwakarma and others, who have definitely worked very hard for last 2 hours. Rajesh ji, thank you very much. Hope to have such kind of cooperation from you
Thank
for
you. It's
next
my duty,
for
sir.
coming years also. Thank you very much, Mr. Rohit Gandhare, to host this session. Thank you very much, everyone, and let us do such more things. Let us all think some more innovative ideas. If we have any suggestions, those suggestions are always welcome in our groups. We will definitely work on those suggestions and improve ourselves by organizing such kind of webinars. As we are conducting online lectures every day, we will have every 10 days or 15 days at least one webinar. That will be our target. So thank you very much, everyone. I think Rajesh ji, thank you very much for giving your
Thank you,
support.
sir.
And
Thank
now
you,
now
sir.
we can leave,
Thank you, sir.
and you can.
Thank you, sir.
Thank you, sir.
Thank you. Thank you very much.
Have a nice day ahead.
You-
Take care.
Thank you, sir.
Thank you.
Thank you so much, sir.
Thank you.
राजेश जी एकदम सुंदर झालं.
Thank you, sir. Thank you.
Thank you very much. So should I leave now?
Yes, sir. Thank you, sir.
Rajesh ji, before I leave, tell Mr. Anup